Thank you for the floor, Katarzyna. My name is János Szinek, and thank you for inviting me to today's conference. Today I will speak about the right to freedom of opinion and expression in the social media, paying a special focus to hyperlinking and liability for comment on the social media platforms. The Article 10, yes, just a second, okay. The Article 10 of the Universal Declaration of Human Rights holds that everyone has the right to freedom of opinion and expression, and this right includes freedom to hold opinions without interference and to seek, receive, and impart information and ideas through any media and regardless of frontiers. However, concerning the online platforms, especially the social media, is not so easy to comply with the declaration. Social media have enhanced the democracy on the internet, but at the same time created new threats that were also previously unprecedented and has challenged traditional doctrines of freedom of expression in ways that are very difficult to address. Social media determines the terms of use on the basis of the contractual nature, so it means that based on the contract concluded by the social media platform and the user. A significant part of the social discourse worldwide takes place on these platforms, and the contractual relationship is used as a reference to determine the scope of opinions that are included or excluded from the social dialogue. These platforms have a major impact on the exercise of users' fundamental rights, and that is why the horizontal scope of fundamental rights shall be enforceable. However, the internet and the social media had shifted the gatekeeping role to a few large global corporations, which are traditionally private actors that are neither part of the public nor media service providers, and can therefore act as a kind of new actor without any major specific obligations, despite the fact that they increasingly dominate the internet. There is both a need to preserve the freedom of social media and to allow as little state influence as possible over them, and the need to regulate them in a reassuringly broad way and to curb the power they currently hold to exert such a strong influence on democracy. It is very difficult to find the right balance between these two competing interests. Regulation of internet infrastructure may constitute a restriction on freedom of expression, and even if it's not aimed at regulating specific content and does not directly seek to regulate what can and cannot be said. Social media expands the possibilities for expressions in general, but it also had the effect amplifying the power of offensive and hateful content, which has also had an impact the increasing frequency of violations of privacy rights and had negative effect on freedom of expression. The judgments of the European Court of Human Rights can provide guidance on the uniform European assessment of content on social media platforms. The European Court of Human Rights has held many times that service of the social media platforms is a means of exercising freedom of expression, and that the protection of Article 10 applies not only the content of the information, but also the means of dissemination, since any restrictions imposed on the latter necessarily interferes with the right to know and communicate information. Due to the given time frame, I would like to pay a special focus on the liability for comments and hyperlinking by presenting 3 cases from the European Court of Human Rights. So back to the basics. The Delphi case concerns Delphi AS, a news portal that was found liable by Estonian courts for its failure to prevent unlawful comments from being published in its comment section, despite having taken down the offensive comments as soon as it had been notified about them. In October 2013, the European Court of Human Rights concluded that the domestic court's findings were a justified and proportionate restriction on Delphi's right on freedom of expression. The case was referred for consideration by the Grand Chamber of the European Court of Human Rights, which confirmed by 15 votes to 2 that there had not been a violation of Article 10 of the European Convention on Human Rights. The court has thus confirmed the decision, and as a result provided an even lower threshold of protection for free expression online than the EU notice and takedown procedure. Briefly about the notice and takedown procedure and the e-commerce directive. Under the e-commerce directive, the platforms like Delphi are immune from liability and provided they remove defamatory content as soon as they receive notice. It is only if they fail to take an action upon notice that they become liable for third-party content, and the shortcomings of these systems are well known. In order to avoid liability, intermediaries tend to remove legitimate content. As the UN Special Rapporteur noted in his report, this has a serious chilling effect on freedom of expression. The decision imposes liability on a news portal for the comments of its user, which is not only flies in the face of regulation on intermediary liability, but is likely to discourage news portal from maintaining comment section onto which users can post freely and anonymously. This will interfere with a valuable forum for expression, discussion, and engagement with issues online and constitute a significant limitation on the freedom of expression. Now a case from Hungary. In this case, the MTE case, the court confirmed that the Grand Chamber conclusion in Delphi, according to which, if accompanied by effective procedures allowing for rapid response, notice and takedown systems can function in many cases as an appropriate tool for balancing the rights and interests of all those involved in a given intermediary liability dispute. While in Delphi, however, this rule was found to be inapplicable as the contested comments constituted hate speech and direct threats to the physical integrity of others, thus allowing contracting states to impose liability on internet news portals when they fail to take measures to remove clearly unlawful comments without delay, even without notice from the alleged victim or from third parties. No such utterances were found, but be at issue in MTE case, making the imposition of a stricter standard unjustifiable. Instead, the rigid stance of the Hungarian courts was found to reflect a notion of liability which effectively precludes the appropriate balancing between the competing rights according to criteria laid down in court's case law. As an ultimate result, a violation of the two internet platforms' freedom of expression was established. In conclusion, the European Court of Human Rights seems to be willing to depart from the much criticized Delphi ruling, but it seems to be limited in its ability to do this. The court identified, in this case, the court identified 5 factors as relevant for the assessment of whether fair balance has been struck by the Hungarian courts in the material. These were the following. First, the context of the content of the comments. Second, the liability of actual authors of the comments, the measures taken by the applicants and the conduct of the injured party, the consequences of the comments for the injured party, and the consequences for the applicants. It is interesting to note that the court gave a new interpretative pattern from the Delphi ruling, and new perspectives were raised with regard to notice and takedown procedure, which now seems to be legitimate in the eyes of the court. In fact, in the same ruling, the European Court of Human Rights found that if accompanied by effective procedure allowing for rapid response, the notice and takedown system could be functioned in many cases as an appropriate tool. This would reduce what was decided in the Delphi case, which appeared to encourage the duty of general monitoring of information. Now, the scope of the ruling appears to be narrowed to cases of hate speech and incitement to violence. And the third case, in this decision, the court confirmed that holding media companies liable for content hyperlinked in their reports violates the right to freedom of expression under Article 10 of the European Convention on Human Rights. The case is an important confirmation in the digital age that imposing strict liability on news outlets and other for the potentially unlawful content of links in online articles and posts create a chilling effect on free flow of information and media freedom. Magyar Yeti is the operator of a Hungarian news portal, which, like many news sites, often uses hyperlinks in the content published on the website, and leading to further information elsewhere on the internet. In September 2013, a group of football fans traveling to Romania stopped at school in Hungary, whose pupils are predominantly of Roma origin, and made racist comments on them. In an interview later that day on the incident, the head of the local Roma minority self-government referred to Jobbik, the right-wing political party in Hungary, which had been criticized in the past for its anti-Roma and anti-Semitic stance. The interview was then uploaded to the YouTube. After that, the Magyar Yeti published an article on the incident that included a hyperlink in the text to the interview on YouTube, but the article itself that did not refer to Jobbik. Jobbik subsequently filed a defamation suit against Magyar Yeti ZRT and others, including operators of the Hungarian news portals. And the first instance court held that in making the YouTube video available through the hyperlink, Magyar Yeti had disseminated the defamatory statements. This decision was upheld on an appeal all the way to the Hungarian Supreme Court before the case was taken to the European Court of Human Rights. Inserting a hyperlink into a news article is not the same as publishing or endorsing what is said and on the hyperlinked website. And nobody should be liable for using a hyperlink where they did not know or had no reason to believe that they technically contributed to the dissemination of content was unlawful. Online publishers automatically liable for hyperlinking would have had a profoundly chilling effect on the right of freedom of expression, as it would discourage the use of hyperlinks and disrupt the free flow of information. Any finding that an online publisher could be properly liable for the content of hyperlinked sites would effectively indicate a wide range of groups, including internet service providers, advertisers, hosting services, and website publishers, that they could be penalized for the content of website over which they have no control. This would not only be unreasonable and unjust, but would create a chilling effect which would significantly limit internet users' ability to exercise the right to impart and receive ideas and information online. The court found that Hungarian application of strict liability of those posting hyperlinks for their potential defamatory content had failed to sufficiently consider the right to freedom of expression and created an undue restriction on this right. In particular, the court noted that significance of hyperlinks to the functioning of the internet and its role in facilitating freedom of expression and information. The court noted that different nature of hyperlinks compared to traditional content publishing, stating that hyperlinks did not present content or communicate it, but directly users to information available elsewhere or called readers' attentions to its existence. Given the centrality of hyperlinks to internet users' ability to access and share ideas and information, a failure by the European Court of Human Rights to acknowledge the impact on freedom of expression in this case would have had far-reaching and damaging consequences. This decision may be an important landmark for safeguarding the freedom of expression online and ensuring access to information amid a worsening environment for media freedom and civic space in Hungary, as well as in the context of an increasingly digital media landscape across Europe. Yes, and it does not seem possible to enforce the doctrines of free speech in the online world as can be done offline. On the internet, the right to freedom of speech seems to have entered a new phase of development, and the legal framework needs to adopt a systematic approach that considers the distinctive features of gatekeepers' activities, keeps track of the changes in them, and provides an accurate definition of what gatekeepers are expected to do and what they might expect from the law, and accurately lays down the gatekeepers' duties and the scope of their liability. So, examining the case law of the European Court of Human Rights, we can witness that exaggeration of liability in the online space can cause a serious chilling effect. The importance of private regulation on online platform will remain, but will be brought closer to the minimum level of public guarantees of freedom of expression. Beyond that, the state regulation, the co-regulation and private regulation of the social media, the minimum standards should be set by the state and should be enforceable by the state. And thank you for your attention. Thank you.